In 2022, a man named Marcus was driving home from a fishing trip in rural Illinois. He got pulled over for speeding. He was polite. He cooperated fully. Then, the officer brought a dog around his truck. The dog sat down. The officer said those 5 words that changed everything. My dog alerted me to narcotics. Marcus had no drugs. He had never had drugs. But in the next 4 minutes, his truck was searched, his fishing gear was thrown across the road, and he was made to stand in the dirt on the side of a highway while strangers went through every corner of his vehicle. No drugs were found. He was sent on his way with no apology, no explanation, and no way to undo what just happened. Here's what Marcus didn't know and what I'm going to teach you today. That dog alert was almost certainly wrong, and the 4 minutes that followed could have gone completely differently if Marcus had known exactly what to say. Today, I'm giving you 4 exact statements, the same statements I coach my own clients to memorize. Each one is backed by a real Supreme Court ruling, and each one does something specific to protect you not just in the moment, but months later in court where it actually matters. So before we get started, please hit the subscribe button and let's get in. The truth about drug dogs, A&D, why it changes everything. Before the 4 statements, you need to understand one thing because it reframes everything. Most people assume a drug dog alert is reliable, scientific, proof that something is wrong. It is none of those things. A 10-year analysis of more than 94,000 drug dog searches found that 75% of alerts produced no drugs. 3 out of 4 times, the dog indicated narcotics and nothing was found. But here is the deeper problem. A study published in the journal Animal Cognition revealed something that should make everyone uncomfortable. Researchers placed handler dog teams in rooms with 0 drugs. They told the handlers that drugs were hidden in specific spots. Every single team produced alerts in the exact spots the handlers were told to look. The dogs were not detecting narcotics, they were detecting what their handlers expected to find. This is called the clever Hans effect, and it means a drug dog alert may say more about what the officer already suspected than about anything in your vehicle. The Supreme Court addressed this in Illinois v. Caballese in 2005, ruling that a dog sniffing during a lawful stop doesn't violate the 4th Amendment. That ruling gives officers enormous power, but it does not mean the alert is accurate. And in Florida v. Harris in 2013, the court acknowledged that the reliability of a specific dog's alert can be challenged in court. That challenge starts at the roadside with what you say right now. Statement 1, stop the clock. The moment an officer says, "My dog alerted," most people go silent or start explaining. Both are mistakes. Your first move is a single calm question. "Officer, has the traffic stop been completed?" Say it quietly, say it respectfully. No attitude, no aggression, just a simple question. Here is why it's powerful. In 2015, the Supreme Court decided Rodriguez v. United States. The ruling was direct. Police cannot extend a traffic stop even by a few minutes beyond the time needed to handle the original violation, unless they have independent, reasonable suspicion of another crime. A traffic stop has 2 phases. Phase 1 is the violation checking your license, registration, insurance, running your information, issuing, or deciding on a ticket. When phase 1 ends, legally, the stop should end. If the officer brought a dog in after phase 1 was already complete or extended the stop to wait for a dog that may be a constitutional violation, your question forces the officer to answer on camera. If he says yes, the stop is complete, you immediately ask, then am I free to leave? If he says no, he has just stated on record that he is extending your detention. Your attorney will use that footage. You are not arguing, you are not challenging, you are creating a record, and records win suppression hearings. Statement 2. Close the consent door. The officer has said the dog alerted. He is likely about to search your vehicle. Before he takes a single step towards your car, you say this: "Officer, I do not consent to any searches." I already hear what you're thinking, but the dog was already alerted. He doesn't need my consent. You're right. Under Florida v. Harris, a credible dog alert can establish probable cause. He may search regardless. So why say it? Because you are not saying it to stop the search tonight. You are saying it to protect yourself in a courtroom 6 months from now. When your defense attorney files a motion to suppress the evidence found in that search, the first thing the prosecution will argue is that you cooperated, that you didn't object, that the search was essentially consensual. The moment you clearly state on camera that you did not consent, that argument disappears. I have won cases where the suppression motion succeeded entirely because my client clearly refused consent on camera. Without that statement on the record, we had no foundation for the challenge. After you say it, add one more sentence. I am recording this interaction for my own records. Take out your phone, make it visible, press record. 2 camera angles of the same stop yours and the officer's body camera protect you from any disputed account of what happened. Statement 3. Force the legal corner. The officer says he is searching anyway. The search is happening. Now you ask this: am I being detained or am I free to leave? This question puts the officer in a legal corner with only 2 exits and both of them benefit you. If he says you are free to leave, you say thank you, officer, and you leave immediately. No follow-up questions, no watching the search. You leave. If he says you are being detained, you ask the follow-up immediately: what is the legal basis for my continued detention? He must now articulate on camera the specific legal justification for keeping you there. A dog alert may justify the search, but does it justify continuing to hold you after the traffic business is complete? That is a genuine legal gray area, and gray areas become defense arguments. Every minute that passes after the original stop should have ended is a potential Rodriguez violation. Every minute the officer cannot articulate a clear legal basis for your detention is ammunition for your attorney. Ask this question once. If the stop continues and nothing changes, ask it again calmly with the same words. You are not escalating, you are documenting. There is a profound difference between those two things. Statement 4. The interrogation shield. The search is underway. The officer is going through your vehicle. And now the questions start. Who does this car belong to? Where are you coming from? Is there anything in here I should know about? Why are you so nervous? This is the moment where most people destroy their own defense. They start talking. They try to explain. They think cooperation at this moment will make things better. Every word you say from this point forward is evidence. And the explanation you think sounds innocent, maybe the dog smelled my gym bag, I had a protein bar with something in it, is now a statement the prosecution can pull apart in court. Here is what you say instead. I am invoking my right to remain silent. Not I don't want to talk. Not I think I should probably stay quiet. Not silence itself. Those exact words. In 2010, the Supreme Court decided Burgui v. Tompkins, the ruling that surprises almost everyone. Simply going quiet is not enough to invoke your Fifth Amendment right. You must say it explicitly. If you just stop talking, officers can legally continue questioning you. Courts have allowed statements made after long silences to be admitted as evidence. You say the words. Then you stop talking completely. Even if the officer keeps asking, even if he says you're making this harder on yourself, even if he says silence makes you look guilty, it cannot. Legally, your invocation of the right to remain silent cannot be used as evidence of guilt. Every pressure tactic you hear after that invocation is theater. You have already said the only thing that matters. The final weapon, and 3 things that destroy your case. If the situation escalates, if you feel you are about to be arrested, if the officer becomes aggressive, if you feel yourself about to say something out of panic, you have one final statement available. I want to speak with an attorney. Under the 6th Amendment, once those words leave your mouth, all questioning must stop immediately. Not after arrest, not after booking, right now. He may still complete the search. He may still arrest you if something is found, but he cannot legally ask you another question about potential crimes. And anything you say after clearly invoking your right to an attorney is inadmissible. It does not exist in court. Clarity matters here. Maybe I should get a lawyer is not an invocation. Do you think I need an attorney is not an invocation. The words must be clear and direct. I want to speak with an attorney. Then you stop talking entirely. Now, 3 things that feel helpful but will ruin your case. Do not explain. I don't have drugs. I swear and maybe it smelled like my prescription are statements. Statements become evidence. You are not explaining your way out of a dog alert. You are building the prosecution's case for them. Do not argue about the dog. Telling the officer his dog has a poor accuracy record is not a legal defense. The roadside is not the courtroom. Save every argument for your attorney. Do not ask, can I just tell you what happened? You invoked your right to remain silent. Asking to talk is uninvoking it. Stay silent. The courtroom is where this gets fought, not the side of the highway at 10 p.m. Here is everything in one place. 4 statements. 5 Supreme Court cases behind them. The moment the dog alert is announced, officer, has the traffic stop been completed? Rodriguez v. United States, 2015. Before the search begins, officer, I do not consent to any searches. Schneckloth v. Bustamante, 1973. As the search continues, am I being detained or am I free to leave? Rodriguez v. United States, 2015. When questioning starts, I am invoking my right to remain silent. Burgess v. Tompkins, 2-1-10. And if it escalates, I want to speak with an attorney. 6th Amendment. These 4 statements do not guarantee you won't be searched tonight. What they guarantee is that you walk into a courtroom with the strongest possible legal position, with a documented record, a preserved challenge, and every constitutional protection intact. Drug dogs are wrong 75% of the time. But the only way that statistic helps you is if you created the right record at the roadside. Share this with someone before their next drive. Not because it's useful information, but because one day it will be the most important thing they ever heard. I'll see you in the next one.